All right. Well, welcome everyone. Thanks for joining for this webinar on a Monday morning. I hope everyone had a great weekend. I'm Jeremy Rogers, the Director of Legal Affairs for the Oregon Realtors. And we are back again with more landlord-tenant law, as we know that is something that you are all facing on a day-to-day basis that's become quite complicated with the legislature's recent enactments. So we are fortunate today to have Bradley Krause here with us. Bradley Krause is a partner at Warren Allen LLP, and everyone congratulate Bradley on becoming partner as of January 1st this year. Bradley works in the firm's landlord-tenant practice and represents many of the region's most successful landlords. He's a graduate of the University of Minnesota, attended law school here in Portland, and graduated cum laude from Lewis and Clark Law School. Along with landlord-tenant law, Mr. Krause assists clients in various civil litigation, probate, and family law matters. So I'm going to turn it over to Bradley, let him walk through his remarks and presentation, and we'll have time for questions at the end, but also if you submit questions during the presentation and they're relevant to the section of the presentation and the topic that we're on at that time, we'll try to get those answered as we go. Bradley, thanks for joining us.
Thanks for having me. Welcome, everybody. Hope you all had a good weekend. I am just returning from vacation myself, so I may have some bags under my eyes, but sometimes when you're on vacation, you stay up a little bit late because that's what you do. But today we're going to be talking about something that makes us all stay up a little bit later at night. House Bill 4401, the state of Oregon's eviction moratorium law, so to speak. It was passed by the legislature on December 21st of 2020 and signed shortly thereafter. It has a dramatic impact on kind of how the state of everything is right now, obviously with COVID going on and the complications with that in terms of not only the health aspect of it, but also some of your tenants probably aren't paying rent and you're probably wondering, what can I do? When can I do it? And what's to come, so to speak. So we'll talk a little bit about all of that today. Just a little bit more about my firm. So we help landlords all across the state of Oregon. So wherever you have properties, we can certainly assist you in compliance with all of the laws that are currently in existence, but obviously there sounds like some more that are coming down the pipeline. We also represent landlords in Washington. So if you got Washington properties, we're happy to help you there too. Anything else? We're a general civil practice firm. We handle many areas of law, all the way through a little bit of criminal here and there. So if you have any problems or anything that you need assistance with, don't hesitate to reach out to me. If I can't help you, somebody in this building definitely can. So we're always here for you. All right, so let's turn over to the lecture materials, and I'm going to try and screen share right now. Jeremy, I think I can, right?
Yeah, you should be able to.
Let's try that. I think you can see that, right, Jeremy?
Yep, looks good.
Perfect. All right.
You might want to increase the size a bit, but we can see it fine. Yeah.
Can do. All right. All right. So what I'm going to be doing here today, folks, is I'm going to be talking through this lecture handout, this lecture material. You should all have that. I'm going to stop here and there at some kind of break points just to ensure that if somebody has a question that's relevant to the topic, we can certainly answer it. But if we get a little bit too bogged down, I might just take questions at the end. But let's try and see how this goes. So, all right. So House Bill 4401 is the current eviction moratoria that we are working with. For the most part, when COVID started, some local jurisdictions had their own moratoria, and that created a complex web of kind of compliance issues in terms of how do we comply with the local, how do we comply with the state. You see it right now in a similar sense when we start talking about no-cause evictions, both at the state level and then in Portland in normal times, because obviously the Portland ordinance has its own set of circumstances and elements that you need to follow when it comes to no-cause notices. But the only place now in terms of eviction moratoria that had something different was Hillsborough. This summary right here is applicable everywhere, but Hillsborough has its own sort of eviction moratoria that I have not checked to see if it was renewed past its expiration point in February. I haven't heard that it was, but the only difference with Hillsborough, and we'll sort of I'll touch on a couple of points. Hillsborough had sort of the standard opt-in. So the tenant had to opt in and actually provide and notify landlords on or before the date that rent was due that they were unable to pay the rent due to substantial wage loss or business loss income. And there was a verification requirement to it as well. So that is obviously different than the state law, which we'll talk about here in a minute. But the only thing that sort of carries over right now, again, assuming Hillsborough's law kind of sunsetted and they defaulted to only House Bill 4401, is that the grace period in Hillsborough law is a little bit more extended than the state law. Hillsborough's repayment grace period goes through August 3rd of 2021. So that's a little bit more extended than what the state law is. So if you've got Hillsborough properties, be careful to comply with the local law along with House Bill 4401, assuming that your tenants have complied with that. Jeremy just put down here, Hillsborough's temporary eviction moratorium will continue through the length of the city's emergency declaration, which was extended to remain in place through April 7th. So it does look like Hillsborough's was extended. Thanks, Jeremy, for posting that. So again, Hillsborough landlords, you have an additional element to your analysis when it comes to evaluating your rights going forward. So keep that in mind if you have Hillsborough properties. The other thing about Hillsborough, the prohibited actions, Hillsborough landlords cannot charge eligible tenants. So eligible tenants would be the ones that provide you with that verification that they have suffered that economic loss, so to speak. You cannot charge eligible tenants for late fees for sums due during the emergency period. So that, again, is a little bit different than what you would be seeing in the state law, because the state law, if your tenant has not provided you with that declaration of financial hardship, the late fees can technically be charged, but we'll talk about some intricacies with that when we go forward on that. All right, so that's all I'm going to touch on Hillsborough. If you have any specific questions related to Hillsborough, I'm happy to talk to you about those separate and distinct from this lecture here. But let's move forward and let's get into the nitty gritty of House Bill 4401. So the problem with House Bill 4401 is it sort of took a choose your own adventure path, so to speak. And if any of you read the old Goosebumps books back in the day, where you'd get to a certain page, you'd read, and it would say, turn to page 68 if you want to go through the door on the right, or turn to page 78 if you want to go through the door on the left. I always kept my finger on the page so that if I went through the door on the right and a monster was there, I could immediately turn back, because I didn't remove my finger from the page. So I actually technically didn't go through the door. But House Bill 4401 doesn't really have that, unfortunately, but it does provide some key terms that we're going to talk about and I'm going to utilize through this lecture. Emergency period and grace period. And those terms have fluctuating definitions depending upon whether something called a triggering event has occurred. So the end of the emergency period and the end of the grace period will have different definitions depending upon whether a triggering event has occurred. And I'll talk about what those are in a second here. So remember, emergency period is essentially the period of time, the protected period during which landlords cannot serve termination notices for non-payment for the non-payment balance that has accrued. And the grace period is the amount of time, the extra time that a tenant has to pay to repay the non-payment balance that has accrued during that emergency period. Okay. The eviction moratoria, House Bill 4401, did not change the beginning of the emergency period. That is still April 1, 2020. Okay. The end of the emergency period, again, depends on a variety of factors, the triggering event, so to speak. And unless the triggering event has occurred, then technically the emergency period ended on December 31. And the grace period for all the repayment of all sums that accrued during the emergency period, so April 1st through December 31st, that emergency period would end in 2 days. The problem, as I'm going to discuss here in a second, is that triggering events are likely to occur. Okay, 99.99% of the time, a triggering event will occur, and we'll talk about that, why that's the case right now, which extends, or it would extend, both the emergency period and the grace period through June 30th. So what is a triggering event, Brad? All right, so if any of the following has occurred at any time prior to June 30th, then both the emergency period, so remember the emergency period, you can't serve non-payment of rent notices during that time. So that's the key point there. And the grace period all extend through June 30th. So one of the triggering events, and this is the most common one, is if you receive the declaration of financial hardship from your tenant. Once you receive that declaration of financial hardship, and we'll talk a little bit more about that document in a second, but once you receive that, then effectively, to summarize, basically all of your ability to do anything with regard to the accrued balance, the non-payment balance, gets told until effectively July 1st, because the emergency period, the grace period, all extend through June 30th. So if you receive that declaration of financial hardship, you can't serve a non-payment of rent notice, you can't charge late fees, and you can't do anything with regard to the non-payment balance. Okay, so that's the most common one, and the reason that it's common, that it's the most common one, is that you have to include, and this is a key point, that if you are entitled and if you can serve a non-payment of rent notice, and we'll talk about that a little bit more down the road here, if you serve a non-payment of rent notice, or if you serve a balance due notice, you must include the declaration of financial hardship form, and you must also include the notice of tenant's rights. Okay, so those are two important forms that you need to know about, and the failure to serve either of those with any balance due notice or any non-payment of rent notice is in and itself a triggering event. Okay, so that's number 2 here. If the landlord fails to serve both the notice of eviction protection and the statutory declaration of financial hardship with any balance due notice or any notice of termination for non-payment of rent, or also any summons for any FED, those 3 things are also triggering events. So let me talk about all of those for a minute here. All right. So when it says any balance due notice served from January 1, 2021 forward, I want everyone to understand that when it says any balance due notice, we're not just talking about your standard form wherever you get your forms from, you know, your standard template. Okay, I have seen tenants attorneys start to argue that simply emailing your tenant and telling them, hey, this is your balance due, is in and of itself a triggering event if you don't include the notice of tenants' rights and the declaration form. Okay, so be cognizant of the communications that you have or have had with your tenants going forward, because if you have had a triggering event, or if somebody argues that you've created a triggering event, that causes problems for your rights going forward. So again, being cognizant of the communications that you've had with your tenants. If you have on-site staff, figuring out what communications that they've had in writing with your tenants is important, because again, if you've had that communication and you haven't included the notice of eviction protections and the statutory declaration of financial hardship form, you may have a triggering event which can complicate things and basically take away your ability to serve a non-payment of rent notice. Okay.
Hey, Bradley, I'm going to jump in with a quick question
Sure.
here, because we are, and if you're going to cover this later, just feel free to do it then. But because we are reaching near March 31st, if a notice is sent related to the grace period balance, which is allowed to be sent after March 30th, 31st, then does the declaration also need to be included there, and the statement of tenants' rights need to be included there? Is that also the triggering event if it's related to the grace period balance?
Yes, you need to include a notice of tenants' rights and the declaration form with any balance due notice. Okay, so any balance due notice, or I would say, heck, just to be safe, any sort of communication that you're having with your tenants related to their balance due. And I've seen this happen. I've seen balance due statements on utility bills, and we've started to have a discussion as to, is the failure to include the notice of eviction protection and the declaration form, if in that utility bill, if the landlord has a third party take care of their utility billing, is that creating a triggering event? It's possible. It's very possible. So we've actually had communications with some of those utility companies to say, hey, please stop doing this, because you could be creating problems. So again, any balance due communication or notice that you're sending to your tenants, I would advise including the notice of eviction protection and the declaration of financial hardship. If your tenant has already submitted a declaration to you, then they're not required to give you another one, so to speak. So don't think that they have to continue to give you declaration forms every month. That's not the case. I have seen some landlords think that was the case. It's not. So get that right off the table right there. Another thing about non-payment notices, those used to be 72-hour notices, is kind of what we would refer to them in Oregon. They are now obviously 10-day notices. That was changed in the law. And so those are now 10-day notices. Technically, if you do not have a triggering event, you can serve non-payment notices for January, February, and now March, just those 3 months if you have not had a triggering event. So keep that in mind. The balance that accrued from April 1st through December 31st, again, if you have not had a triggering event, is technically comes due on April 1st. But again, keep in mind that your tenant can submit, and likely will submit, that declaration form to you. And that will again push back everything until July 1st in terms of what your rights are with regard to those amounts. Finally, this is one that a lot of you probably don't deal with. This is more kind of my side of things when we file eviction actions. And there was a question, an FED is kind of the short version of eviction action. The FED or eviction statutes are Chapter 105 in the Oregon statutes, and a lot of landlords just say FED to kind of shorten things up. But any summons that you have for any eviction, even conduct-based evictions, you must include the declaration of financial hardship and the notice of tenants' rights with that summons. And we have that, in our forms, because we have a process server that we work with who serves a lot of FEDs. So you don't need to worry about those. But again, that's more on my side of things. And finally, in terms of damages, the failure to serve the required forms can create liability of up to 3 months rent plus actual damages and attorney's fees. So again, it's important that you understand the forms when they're needed, which is likely always, and what you can and can't do if you receive one of those declarations. So if you have any questions about that, I'm happy to help you in terms of navigating all of that. So there's a couple of questions here that I'll just take quickly. What if your tenant has requested an account statement? Good question there, simply because, is that sort of a balance due notice if your tenant just requests something? Probably not. I don't think it would be. But again, I don't think it hurts to include that notice of eviction protection and statutory declaration form, simply because at that point you're just doing overkill, right? And I always prefer overkill to underkill, because at the end of the day, you likely will not get killed for overkill. If you underkill and don't take care of things, that can create issues. But again, I always prefer overkill. Do you have to include the required document each time you submit a non-payment, or just the first time? I'm not sure I understand the question. If you're excuse me, if you're saying, do you need to include the notice of the declaration of financial hardships and notice of tenants' rights with every non-payment of rent notice that you serve? The answer is yes, but you probably won't get to that point, because and when I say you won't get to that point, you won't get to the point where you're serving multiple non-payment of rent notices during this period of time, because once you serve that non-payment of rent notice and include that declaration form and the notice of tenants' rights, either your tenant is going to turn in that declaration form to you, which will again stop everything that's happening, or if they don't, and they don't pay the amount that's due and owing, it's time to file the eviction action. Now, remember, and again, this is 2C that we were talking about. Once we file that eviction based upon that non-payment notice, that summons also has to include the notice of tenants' rights and the statutory declaration form. And I'll talk about that a little bit more because I know that's in this handout, but I'll just touch on it here. Your tenant can submit that form to you at any time, even during what's called the first appearance, the kind of the first setting in the eviction action. And once they turn that into you, even if it's at the first appearance, the landlord has to dismiss the eviction action. You have to. So that's a long way of answering the question that I think you're asking, which is you likely will not be serving multiple non-payment of rent notices during this period of eviction moratorium. Okay. I did not receive this written information. Will it be emailed? Jeremy, I think.
Yeah, I just want to. If it's okay with you, Bradley, we'll share it with the attendees. Yeah.
Please do. Yeah. Finally, one additional question here. I have tenants that have agreed to move due to conduct issues. Now they're saying they won't. Do we have to include the documents when serving a notice to terminate their rental agreement? I want to be careful when you say notice to terminate their rental agreement, because again, if we're talking no cause, there's eviction moratoria that we're dealing with. If you're talking a for cause notice or something like that, no, these documents do not need to be included with for cause type notices. So that's a good question there. All right. So let's move on. Let's talk about the declaration in and of itself. So again, this is a statutory form. Okay, it is in the House Bill 4401 itself, so you can pull it from there or you can pull it from the internet. The tenant can return that declaration to you in any format and by any method. Okay, so photo, mail, email, text, give it to you by hand, post it to your door. They can basically do anything, and that's kind of the moral of the story when you have tenants in Oregon, as you've probably seen. The biggest problem with the declarations, and this is kind of the largest problem that I have with Oregon law, is that you cannot challenge the declarations in any way. Okay. You cannot challenge it. So if your tenant owes you a large sum of money, okay, and they hand you a declaration of financial hardship and they drive away in a Maserati, you can't do anything about it. And I understand that that is frustrating. I understand that they are lying. I understand that that is fraud. It really is. Unfortunately, the legislature has created such a problem in the language because, again, only landlords commit fraud. And again, if you couldn't tell, there was quite a note of sarcasm in my voice there. There is no way to challenge this form. So that is the main takeaway here. Landlords cannot request verification. You cannot request additional information. And any attempt to do that will result in liability of up to 3 months rent plus actual damages. In reality, the sole potential for the legal liability associated with that financial hardship is that if is when a landlord fails to provide it. But the landlord can be held liable for significant monetary damages if that's the case, in addition to the emergency and grace periods being extended. Okay. I know that's tough to believe because we all believe that, hey, there should be a remedy for these sorts of things, right? And that the declaration form says that it's, that the tenant has to, they have to be telling the truth, right? Yeah, that's what it says. But as we know, people lie. And I can give you a variety of stories from clients of mine that have received a declaration form from their tenants only to see that tenant either A, drive away in a new car, or B, a week later, receive basically a verification request from a financial institution who's going to be providing a loan for a house from these tenants or for these tenants. So again, that sort of thing does happen. It's unfortunate. And I have openly invited our legislators in some of the articles that I've drafted to contact me about this and this problem. None has taken me up on it yet, and that's unfortunate, but not surprising. Other things about the declaration: one tenant per household. Only one tenant per household needs to sign the declaration form, and it only needs to be signed once. You cannot require a tenant to provide more than one declaration of financial hardship. You cannot require every tenant to provide you one. If you get one, that satisfies for that household. And again, that extends the emergency period and the grace period through June 30th. Languages: the landlord must accept declarations in other languages. So if you receive one in a different language, don't automatically cast it aside because, again, it might satisfy the moratorium. And finally, once you receive that declaration, again, keep in mind that you have to cease all of your actions. So if you have an eviction action that's currently pending, you would have to dismiss it. If you have served a non-payment notice and your tenant submits a declaration after that, again, you have to stop. No non-payment of rent actions can be commenced. And again, that basically extends everything and puts everything on pause until July 1. Once a landlord has reason to know that the tenant has given a declaration, again, the landlord must immediately halt all non-payment until July 1st. And a failure to do so, again, creates liability of up to 3 months of rent, actual damages, plus attorney's fees. All right, couple of questions, or one question here. I think sorry, my throat's a little dry today. How long is this declaration going to be allowed to be submitted by tenants? These declarations can be submitted and turned into you at any time, all the way through June 30th, as things stand right now, okay? And obviously, once we get to July 1, assuming no further legislative action, then things will go back to some semblance of normalcy. What I can tell you, and I'm sure as some of you have probably been following the law, there is legislation that is pending before the Oregon legislature that would extend basically the grace period, so the amount of time that your tenants will have to repay you the unpaid balance that is accrued. It sounds like there's a push for that to be until February of 2022. The only positive, I guess, with regard to that piece of legislation is that it doesn't extend the eviction moratoria as things currently stand. So again, keep a lookout for that, because that could be coming down the pipeline, and it could vary some things with regard to this handout in terms of what you can and can't do. But again, unless and until that legislation passes, here's what we have. So again, keep your eyes peeled on that, because it will be important to things going forward. Alrighty. There is one other question here. So it looks like, there's a question here with regard to, it looks like a non-renewal. I will cover non-renewals here in a moment down the road here, but effectively, I'll kind of shortly answer this question, and I can't really understand because some of the dates it looks like are weird. But you cannot during this period of time non-renew. But the good thing about that is that the eviction moratorium has extended what's called the first year of occupancy, which can allow you some no-cause rights down the road, or some non-renewal rights down the road. But again, I'll talk about some of that down the road here. But again, I don't really understand the question based on the dates. Okay. All right. Finally, I'll just answer this other question here. So if a tenant owes you money and took off, can a landlord sue to recoup monies after July 1st? Yes. The answer to that is yes. Alrighty. All right. So moving forward here, what is the earliest possible date I can serve a notice of termination for non-payment? Okay. The earliest possible date that you could do that would be January 8th of 2021. That was the earliest date. And again, right now, if you have not received any declaration of financial hardship or had any other triggering event, again, you can serve a non-payment of rent notice right now. Again, the requirements for that is, again, if and only if you have not received any sort of declaration of financial hardship or had any other sort of triggering event, then you may have some non-payment of rent notice rights, and I can certainly assist you with that. But again, the couple of things to keep in mind on that, and it's addressed later in this handout, so I'll touch on it again. They are now 10-day notices. So if you're mailing them and you're only mailing them, then they would be 13-day notices. So that's the important thing to keep in mind with regard to timelines. Again, if you're serving those notices, make sure you include the declaration of financial hardship and the notice of tenants' rights. Okay, so that's the other thing. And 3, again, making sure that you haven't had any sort of triggering event that's occurred. If you have any questions about whether or not you have had a triggering event, please reach out to an attorney and talk to them about it, because that's important, okay? All right. So I guess the next section here is kind of what I was just talking about there. Quick question here. So if you serve a notice of termination for non-payment and have included the statutory notice of eviction protection and declaration of financial hardship form, then the tenant's return the declaration of financial hardship, then does that supersede the landlord's rights under the non-payment of rent? Effectively, I think the answer to your question is yes, but what you need to remember is that once you get that declaration of financial hardship, you have to stop what you're doing. And it basically tolls everything and stops everything, so that the next point of time when you can evaluate what your rights are is going to be July 1st. Okay, so that's the important thing to keep in mind. If you get a declaration of financial hardship, the legal effect of that is it extends the grace period. So it extends the amount of time that your tenants have to pay you back all of the money that's owed to you until July 1st. And it extends the emergency period, which basically is the eviction protection that tenants have through July 1st. Okay. All right. All right, folks, I'm going to cover a couple of other things here, and I'll try and address the questions that we have in the chat here after I'm done covering this topic here. Okay. Again, so special rules for notices of termination for non-payment of rent, and this is through June 30th. Okay, so these additional protections, they sunset, according to House Bill 4401, they sunset on July 1st. So on July 1st, hopefully, pending no further legislative actions, things will go back to normal. So again, I've touched on this already. They're now 10-day notices. Okay, they're not 72-hour notices. You can still serve them on the 8th, so they still can't be served until the 8th day of the rental period. So if rent is due on the 1st of the month, that means the 10-day notice for non-payment of rent can't be served until January or until the 8th of that month. So again, let's take April. Rent's due on April 1st, according to your rental agreement. If you are entitled to serve a non-payment of rent notice, then you could technically serve one on April 8th. But again, it must be 10 days. If you're doing it only via first-class mail, you need to add 3 extra days for mailing. That's pursuant to statute. So then it becomes a 13-day notice, so to speak. And again, you're also including that declaration form, the notice of tenants' rights with that as well. All righty. And keep in mind that a triggering event, and we've talked about this before, but I'll say this again, a triggering event can occur at any time. And once it does, the emergency period and grace period are extended through June 30th. And you can no longer serve a 10-day non-payment of rent notice effectively until July 1. Again, that point has been repeated consistently, but I'm going to continue to repeat it because, again, it's important. And I've already touched on this as well, but the likely outcome, and again, this is the most likely thing that's going to occur. When the tenant receives a notice of eviction protection and a declaration of financial hardship form, they're likely going to return that to you, okay? So again, it's game over for non-payment at that point until July 1st. Even if they don't return it to you at that time, again, once you file that eviction, they're going to receive that summons, and that summons is also going to include the declaration of financial hardship, notice of tenants protections. So they'll probably send it to you at that time. And honestly, if you get to the first appearance and your tenant still has not submitted that to you, they're probably going to have those forms in the courtroom, and the clerk and or the judge is probably going to tell your tenant, hey, have you heard about this declaration of financial hardship? If you fill one of those out, this whole thing will stop, okay? So again, simply because you can serve a non-payment of rent notice, I don't want you to get your hopes up and thinking that the process will be completely smooth sailing and you'll evict your tenant, because again, there are way too many easy things that your tenants can do to halt that process, okay?
Bradley, I know you've still got a lot to get through, so I don't want to overload you with questions, but I just want to throw one out to you because I think it's relevant to everything you're talking about that we received in the Q&A. So the question is, I understand the declaration only needs to be by one tenant in the household. What if you have 4 tenants and they are all on their own rental agreement separate from each other? Still only one declaration required?
Yeah, so that's an interesting question, and it's one that I can't really answer without taking a look at your documents, because what I think you have is, I think you have a rumor situation. And if you have a rumor situation with all your tenants on separate rental agreements, so effectively they're kind of single room occupants, then it would be my opinion that that each of those tenants would have to submit their own declaration in order to be protected. But again, that answer should be taken with this caveat. I would really need to look at your documents before I could advise you fully, because a lot of landlords do this sort of situation, and then we kind of get down into the nitty-gritty of things, and it turns out that maybe their documents don't line up. Maybe all of these tenants are actually on one lease, or maybe something has occurred which makes it seem like it's just one tenancy as opposed to 4 separate tenancies. That's the real kicker, is whether there is one tenancy or whether there is 4 tenancies. Because if there's 4 tenancies, then each tenant would likely have to submit a declaration. But again, if there are facts that come out in which it looks like maybe this is all one tenancy, then no, you could not require a declaration for all of those. So again, I want to be cognizant and of kind of the unique circumstances here, and that I would need to see your documents before I could give you a real kind of concrete answer. But that's how I would evaluate that, okay? And it looks like there was one sort of follow-up to that, so I'll answer this. If you have 4 tenants and they are equally held responsible for the entire amount, would anyone justify the meeting of that requirement? Yes. I think what you're talking about there is if you have tenants who are jointly and severally liable, then yes, then only one declaration would be required. But again, most of the time, if you have tenants that are all jointly and severally liable, it means that they're all on one rental agreement. So so that would only require the one declaration form. And finally, this is the last question I'll answer, and I'll move on here. If you have a tenant who is on a month-to-month contract and the tenant has agreed and signed a cash for keys offer to move out in 60 days, would you still need to serve them the declaration form and the notice of tenants' rights? Just with what you currently have there, the answer is no, because you're not serving them any sort of balance due notice or any non-payment of rent notice. If they don't move out in those 60 days, and again, I would have to take a look at the document that you have in order to know kind of what it looks like. But if they don't move out and that document contains all the right language, all the magic words that I would look for in order to allow us to file an eviction, then once you file that eviction, is that summons that would basically call them to court for that eviction action, that would need to include the declaration form and the notice of tenants' rights. But that's not something, unless you file your own eviction actions, that's not something that you would be intimately involved in. That would be something that I would deal with, or your attorney would deal with. All right. So let's move on here. Sorry, folks, I'm drinking a lot of water today. Again, I was just away from the office for a while, so I'm not used to talking. Question that always comes up, and this is something that we address: can I just wait until April 1st and then serve a 10-day notice for April 2020 through March 2021 rent? The answer is sure, if you meet all of the above requirements. So again, if there hasn't been a triggering event, then come April 8th, technically, because again, you can't serve a non-payment of rent notice for April's rent until the 8th day of the rental period. But if you meet all of those requirements and there's no triggering event, then you can technically serve that balance, or that non-payment notice, because the emergency period would have ended on December 31st of 2020. There's a typo there, unfortunately, and that would end on March 31st. So again, going into April, you would have all of your rights, so you could serve that non-payment of rent notice for that entire time. But again, keep in mind, as we've been discussing here, folks, as good as this might sound, it doesn't actually put you in a better position than serving a 10-day notice effectively right now, because as long as the tenant sends you that declaration of financial hardship, again, everything gets pushed out. So whether you serve a non-payment of rent notice right now for just January, February, and March's rent, or you wait until April 8th, and again, assuming there hasn't been a triggering event, you serve a non-payment of rent notice for the whole kit and caboodle of what's due to you, then again, the tenant, all they have to do is send you that declaration form, and it pushes everything out to June 30th. Okay. All right. So the follow-up question that we always get: when can every landlord serve non-payment of rent notices of termination for non-payment of rent? July 1. Okay. That is the answer to the question. July 1. And again, if you're talking July's rent, it would be July 8th for July's rent. But again, July 1 is the date when things will hopefully go back to normal. There is one caveat to that, to the July 1st date, and that is unless the landlord is seeking compensation under the Landlord Compensation Fund. Okay, and I will touch on that in a second in terms of what that additional piece means. But the key takeaway here is that as of July 1st, pending no further legislation coming through, things will go back to normal on July 1st. Okay. All right. So I'm not going to cover the additional. I already covered that quite a bit. All right. So let's talk a little bit about balance due notices, courtesy notices before the grace period ends. Again, beware of this disclosure trap. Before the applicable grace period ends, a landlord may provide a written notice to a tenant stating that the tenant continues to owe any rent due. The notice must also contain a specific disclosure. And this is the additional piece of the choose your own adventure path, unfortunately, because the precise disclosure language that needs to be included in the balance due notices depends on whether or not a triggering event has occurred. Okay, whether or not the emergency period is still that March 31st date, or whether it's been extended by a triggering event to June 30th. Additional documents must be enclosed along with that balance due notice. So again, those additional documents are the declaration form, the notice of tenants' rights. Okay, if no triggering event has occurred, then again, in the notice itself, the notice can state that the tenant continues to owe any rent due, and must also state that eviction for non-payment of rent, charges, and fees accrued from April 1st, 2020 to December 31st, 2020 is not allowed before March 31st of 2021. Okay. And I know this is probably a little bit confusing, so I'll kind of summarize this after I'm done going through all of this, okay? The balance due notice can offer a voluntary payment plan for the non-payment balance, but it must expressly state that the payment plan is voluntary. It can request that the tenant contact the landlord to discuss the voluntary payment plan, and can also include information regarding tenant's resources, okay? And again, I've also stated multiple times, but I'll state it again, notice of eviction protection, declaration of financial hardship form, okay? If a triggering event has occurred, then your balance due notice needs to look a little bit different, okay? If a triggering event has occurred, then the notice can state that the tenant continues to owe any rent due and must also state that eviction for non-payment of rent, charges, and fees accrued from April 1st to June 30th, 2021 is not allowed before June 30th of 2021. So that's the distinction there, folks, is that what needs to be in your balance due notice is different depending upon whether or not a triggering event has occurred. And it goes to basically the deadline or the timeline for eviction, and what the grace period is, so to speak, or the emergency period. Okay, and what I will tell you is that if you get your forms from a reputable form dealer, or you have somebody that's drafting your forms for you, they probably cover this in one notice. So their notice, their balance due notice, probably contains statements that cover kind of both choose your own adventure paths or whether or not a triggering event has occurred, okay? That may be perfectly fine. It may be. I have not heard any sort of challenge to that at this point. What I will tell you is that when I draft my balance due notices, I figure out whether a triggering event has occurred or not, and I specifically go with the language applicable to that situation, because tenants' attorneys are crafty, and somebody might argue that if your notice contains both disclosures, then it's technically not valid. I would disagree with that. But again, tenants' attorneys will argue anything that they can to put heat on you as a landlord. So that's why, again, I prefer the overkill method. And in this case, it would simply be sticking to the direct language of the statute, rather than kind of, lumping everything together and hoping for the best. Again, I have not heard any such thing being challenged. And I know there are reputable forms makers that contain kind of all-encompassing language. And I think that is fine. But again, tenants' attorneys will argue anything that they can to put you on the spot, okay? All right, so if the tenant has already turned in a declaration of financial hardship form, the landlord is not required to include the statutory notice of eviction protections and a declaration of financial hardship form, okay? Can a landlord choose to send these forms anyway? It seems difficult to imagine that sending these forms, even when not required, could be construed as a violation. If a landlord wants to serve these forms, even when it's not required, the landlord should include a statement that says, if you've already provided a declaration of financial hardship form, you do not need to include another one. This avoids any argument that the landlord is implying that the tenant must provide more than one declaration. All right. Any departure from the authorized contents and or failure to serve the required forms creates that liability for 3 months worth of rent plus actual damages. So again, you want to avoid that. And that liability trap that we were talking about, the balance due notice provision is a liability trap for landlords. It requires a landlord to basically track on a tenant by tenant basis whether a triggering event has occurred and insert a differing end date based on this factor. If the landlord makes a misstep and inserts the wrong end date, then again, the landlord can potentially be liable for 3 months worth of rent, actual damages, and attorney's fees. I want to emphasize this because, again, this choose your own adventure path is confusing and it's complicated and it's designed to trip you up. You as a landlord do not need to serve balance due notices on your tenants. Period. End stop. Okay? You don't. The rent continues to be due and owing. There's nothing that you need to do in order to continue to make that the case. Okay? So you do not need to do this sort of thing if you're hesitant or you're saying, look, I don't want to deal with the trap that comes with a balance due notice. That's perfectly fine. One of the main reasons to serve a balance due notice or a non-payment of rent notice is to get that declaration form from your tenants. Some tenants simply do not want to help their landlord. They simply want to watch the forest burn just to watch it burn. The service of these types of notices can create a situation where the tenant is prompted to return that for you. And the reason to get that declaration form is, again, the landlord compensation fund. Talk about that in a second, okay? So again, I want to calm everybody's mind because I know everything I just said there and everything I was just talking about for the last probably 10 minutes is confusing as all heck. And I would agree with that. But you don't need to do it, okay? So keep that in mind. All right, a couple of questions here before we kind of move forward. Will these rights also stick with somebody who purchases a home that is currently being rented? So what I think you're asking there, so I think would it transfer to the new buyers? I think that's what your question is. And if your buyers are purchasing if buyers are purchasing a home and they are becoming landlords, then yes, they are technically landlords, and everything that happened before would technically transfer to the new landlords. It's not as if selling the property can get you out of the eviction moratoria. If your buyers are the new landlords, so to speak. But again, I think that's what your question is. If it's not, we can certainly follow up. What happens if a tenant starts to not pay rent on or after April 1st? Well, again, once the 8th day of the rental period rolls around, we can certainly talk about service of a non-payment of rent notice. But again, keep in mind that all they have to do is turn that declaration form into you, and then everything gets extended, everything gets stopped until July 1st. Okay, so if no rent is paid starting April 1, then again, we can certainly evaluate your rights, assuming you haven't had a triggering event. Okay. All right. So couple more questions here. If a month-to-month tenant has submitted a declaration of financial hardship form, can a landlord give a cash for keys agreement to them to be out by July 1 or sooner? So cash for keys is okay. You can certainly have discussions with your tenants about cash for keys or a waiver of rent, so to speak. So that's something that you can certainly do, but it needs to be done a bit delicately. So it's something that I'd probably have you talk to an attorney about, because when I create sort of these communications to tenants, they're very I don't know, cordial and saying, hey, it's been a good run. Your landlord has some plans for the property, and I know that will cause you some hardship, but they want to make it worth your while too. And that's kind of where you roll into things. So again, it's something that you can do. I've done cash for keys during the moratoria this whole time. And it's certainly appropriate, but again, it's something that you want to work with an attorney on, because it is a delicate situation. I signed up for the landlord compensation program. It is only for $12,000 and one tenant out of 10. Can I withdraw my application at any time if it goes on too long and they have not approved me? That's an interesting question. I don't know the answer to that. I would assume yes, but that is probably something that you may need to talk to the folks at the state about, because effectively what you would be basically doing is saying, hey, I don't want your money. I'd rather go after the tenant for it. And I don't want to waive 20% of the balance due, which in my opinion would be your right. But again, I don't think the state would have a problem with that. But again, it's something you probably should call them and talk to about in terms of the process. But I think the answer is yes, you could, because I don't see why you wouldn't be able to do that. Please comment on how to serve up rent notice. I don't know what you mean by that question. If you're talking about a rent increase notice, rent increase notices are not prohibited right now. It's you can certainly serve them. Your cap on rent increases is 9.2%. So keep that in mind, but I'm not quite sure I understand the question. Finally, and then I'll move on to some other issues. Can the landlord offer a settlement for the past due? I think we were just touching on that with regard to the cash for keys. But yes, the landlord can engage in conversations with their tenant with regard to saddling up, so to speak. So there's nothing that prohibits that right now. Again, if you're looking to do a cash for keys situation, so effectively a waiver of rent or a payment of some money of some kind in exchange for your tenant vacating, that's something that you want to work with an attorney on, because again, it's a delicate process. It's something that you can do. But again, there are some tricks to that trade. So something you want to work with an attorney on. All righty. So continuing on. All right. So House Bill 4401 also prohibits landlords from taking the following actions before the end of the applicable grace period. So no reporting. You cannot report a non-payment delinquency to credit reporting agencies. The important thing to remember there is, and I've been telling my clients just to keep these things in-house, because sometimes if you have a third party that does your collections, they can do certain things that can blow back on you as effectively a debt collector. And can cause you some issues under the state's Fair Debt Collection Practices laws. I'm not an expert on that. Other attorneys in my firm are experts on that. But again, it's important to keep those things in mind, because again, those can have some blowback on you. So again, if you have any questions on that, I can certainly point you in the right direction. Another attorney in my firm, Anna McCormick, deals with those sorts of issues. But again, just keeping that in mind. No civil action. So landlords cannot file a civil action against the tenant for the unpaid balance. In other words, a lawsuit or a small claims case. House Bill 4401 tolls the statute of limitations for actions based upon the non-payment balance to July 1st. So effectively kind of pauses in time. Unfortunately, the legislature has also extended the statute of limitations for many items. They did that in a separate House bill. I think that was House Bill 4212. And so that does cause some problems in terms of defending lawsuits and the like. Yeah, I am aware that I've only discussed non-payment issues right now. We're working our way through the handout, so I'll discuss some other issues in a minute. All right, so the other thing, no late fees. Landlords cannot assess a late fee for the late payment of rent. So that was one of the other items that's been consistent through all the moratoria, is that late fees cannot be assessed. The real question becomes, what happens if your tenant doesn't pay you rent for January and February, and you serve a non-payment of rent notice, and obviously they're late at that point, so late fees would have accrued. Once they serve that declaration form to you, what does that mean for those late fees? Well, I have heard some tenants attorneys take the position that that late fee would need to be thereafter removed because the tendering of that declaration form would then mean that the rent is not technically due, so therefore it's not technically late. It's an interesting argument, and it's one that, you know, for the most part, when it comes to those late fees, you're only talking 75, $100. So it's probably best to avoid that argument, that case, that litigation, because again, I mean, if you want to spend tens of thousands of dollars litigating that point, I'd be happy to do it for you. But you probably don't want to pay me tens of thousands of dollars to litigate a point over a couple $100. And honestly, if you wanted me to do that, I would probably try and talk you off that ledge pretty quickly because, you know, again, it's probably not worth your money. But again, hey, I'm here for you if you need anything. Finally, no interference with possession. Again, if the grace period has been extended, you know, you cannot take any action that would interfere with the tenant's possession or use of the dwelling unit based upon the tenant's non-payment balance. So that's the other kicker there. All right, continuing forward, because I know it seems like people are antsy for me to get to some no-cause items, which is after this page. So I'll touch on that in a second. Just let me finish this up here, and then we'll go to that. Landlords can withhold unpaid rent balance from the security deposit. This was new in 4401. If the tenancy terminates before the end of the applicable grace period, the landlord may claim the security deposit or last month's rent to repay the unpaid balance or the unpaid rent balance that accrued during the emergency period. Okay, so that's important there. House Bill 4401 did not clarify whether the grace period still applies post tenancy, and that's a problem that we've been having because, you know, effectively, let's say, for example, your tenant served or sent you a declaration form, which would extend the grace period through June 30th of 2021. Let's say they thereafter move out. Let's say they move out today. Do they still get the benefit of that grace period? It's really unclear. What I would say is to take the conservative approach to that and just assume yes, that they do. You know, if there is additional legislation that comes through, hopefully they will clarify that point. But again, it's not something that's real clear in 4401, but I would advise my clients, and I have advised my clients, to take the conservative approach and just assume that it does. The House Bill 4213 grace periods, the previous grace period notice, if any of you were following the laws back with the previous eviction moratoria, there was an allowance for a landlord to serve a grace period notice, and if the tenant didn't return that, then the landlord would have been allowed to basically charge an additional half month's rent. That has been eliminated. Can't do that anymore, okay? Application of payments. The application of payments provision has been extended. So all payments must be received and applied in the following order. Prior to applying the payment to the non-payment balance, it needs to be for rent for the current rental period, utilities, service charges, then go to late rent payments, and then finally fees or other charges owed. Effectively, the main takeaway there is if your tenant tenders you a payment of some kind, there is a specific way that the law calls for that to be applied, and that can have effects on your notices and what notices you're able to serve. So again, if you're looking at termination options, and this is the main takeaway here because it's difficult to cover all application of payments questions. If you're accepting partial payments from your tenants, so if your tenants are giving you kind of cash as things go, it's important to work with an attorney based upon your termination rights, because again, the acceptance of those payments can cause some partial payment problems when it comes to certain notices. So working with an attorney is important on that front. Finally, as I've discussed throughout, but I'm going to say it one more time, the odds of a landlord being able to carry out an eviction for non-payment of rent right now, all the way through the process and obtain a judgment, they're very slim. Okay, because again, that declaration of financial hardship just needs to be returned, and that's pretty much end of story if it's a non-payment issue. All right, conduct-based issues you are still allowed to evict tenants for. Okay, so remember that. This does not affect your rights as to conduct-based evictions, okay? So if your tenant is making noise at all hours, you can certainly still serve a for-cause notice for that. If your tenant shoots somebody on the property, you can still serve a 24-hour notice for that for outrageous conduct, okay? So keeping all those things in mind, I'm going to answer a few questions, and then we will move on to some items related to no-cause terminations. All right. What if a landlord or family member would like to move in? So I think what you're talking about there is a qualifying landlord exemption that is available to you under state law. The House Bill 4401 doesn't prohibit qualifying landlord exemptions. The previous eviction moratoriums did have some complications with those, but again, qualifying landlord exemptions, so they would be, sale, family member moving in or landlord moving in, demolition or the sale of the property, or wait, I covered that twice, repair, remediation, significant repairs, remediations that would cause the unit to be uninhabitable. All of those things are available to you, so you can still do those. The important thing to remember is that qualifying landlord exemptions are tricky. There's a lot of steps to them, and there could be some relocation assistance that may be necessary to be paid. And if you're looking at a property, if you're looking at doing this for a property in Portland, then the rules become even more tricky. So if you're looking at utilizing a qualifying landlord exemption, again, work with an attorney because it's important to get it right. What if you want to sell the property? Can you serve a notice? Again, that's a qualifying landlord exemption. Those are available to you, but there are certain elements that need to be met with regard to that qualifying landlord exemption. So the sale exemption, it needs to be 90 days. You need to be selling the property to a buyer who intends to occupy the premises as their primary dwelling unit. And you need to provide evidence of basically the accepted offer to the tenant, probably right when you serve that notice. Again, and then there's relocation assistance that may or may not need to be paid, depending upon the amount of units that you have and or where your property is located, because Portland has its own sort of set of circumstances that you need to comply with. Okay, so
Bradley, I wonder if you could just chime in on one thing related to the qualifying landlord reasons that's come up because of 4401 and the eviction moratorium. That is that traditionally originally the qualifying landlord reasons are in statute for after the first year of tenancy. And the reason is because in the first year of tenancy, without eviction moratoria in place, you could do a traditional no cause 30-day. Now we have a situation where people are in the first year where they want to use the qualifying landlord reason, but the statute doesn't appear to authorize it. And I wonder if you could comment on that.
Yeah, and it's interesting that you brought that up, because I've actually worked through that problem before, and I can't remember exactly how I analyzed it, and I think you got me stumped on that one because yeah, I'm trying to think of how I analyzed it, because I did recognize that problem because again, it does create sort of a loophole. I don't have an answer for that right now. Let me take a look at it and look back at how I analyzed it before, because in order to do that, I'd want to have both the statute and House Bill 4401 in front of me. But that is a great question, and it's something that I've encountered one time, and I can't remember exactly how I analyzed it. But let me take a look at it, and I'll certainly provide you an answer that you can forward to everybody that's signed up today.
Great, thanks so much. Appreciate it.
All right, a couple more questions here and then we'll move on. I have a client who would like to sell their rental property. They use a property management company. The lease is up in May. The tenant has paid all rent. Is the first step to give a notice of non-renewal of the lease before April 1, then speak to an attorney to discuss cash for keys? Well, you can't serve any non-renewals right now. We'll talk about that in a moment. But a cash for keys could be right up your alley. If you're in the first year of occupancy, that period of time has been extended post eviction moratoria. So that could still be available to you. And again, if you are able to utilize a qualifying landlord exemption, then again, that's certainly something that you can look at. But again, speaking with an attorney about that qualifying landlord exemption is going to be important for you to get that right. But again, and this kind of goes to your last point, the cash for key situation is open to you at any time. You can certainly do that right now, okay? But working with an attorney on that is going to be important. All right, so does a squatter become a tenant after a period of time? This is the final one that I'll answer. And then it looks like there's another question that I'm going to cover the no-cause stuff, and then I'll circle back to. Does a squatter become a tenant after a period of time? There is no such thing as squatters' rights. There is no such thing as, what have I heard a cop say it as? Establishing residency. There's no such thing in the Landlord Tenant Act. Anybody that tells you otherwise is wrong. The main thing that establishes whether or not somebody becomes a tenant is whether or not there is a rental agreement, whether it's written or oral, and or whether or not the landlord has effectively accepted consideration in exchange for the privilege to live there. So that's what establishes a tenant. Squatters don't just become tenants. Somebody who lives somewhere doesn't just establish residency and then therefore become your tenant. It irritates the living daylights out of me because I've heard police officers say that when it comes to disputes between landlords and some random person who's living there, and they don't seem to want to listen to me when I tell them they're wrong, but that's a different question. All right, so on to no-cause terminations, no-cause notices. All right, so no-cause notices, landlords cannot serve a notice of termination without cause, and that's just a straight no cause, okay? We're not talking qualifying landlord exemptions, we're talking straight no causes. Or file an FED based upon a no-cause notice before January 30th, okay? This includes non-renewals. So again, you can't non-renew your tenant's lease and file an eviction on that until basically July 1. The key point there is that the first year of occupancy was extended, okay? So for purposes of no-cause terminations and non-renewals, which are already limited by pre-pandemic Oregon law, the first year of occupancy is extended to August 31st. So again, if the first year of occupancy would have normally ended after April 1st of 2020 and before August 31st of 2021, it is thereby extended. So that's going to give you the ability to serve any sort of no-cause notice, just straight no-cause notice, assuming you're able to. And again, I say assuming you're able to because, again, local restrictions like Portland will bring in some relocation questions and whether or not you want to pay that or whether or not you're able to non-renew. Again, those items have been extended, okay? And finally, qualifying landlord reason terminations are allowed. Again, as we've discussed, the qualifying landlord exemption, those notices are available to you. And you can certainly do those. Again, working with an attorney is going to be important on that point because, again, there are specific requirements that need to be met. There are specific things and boxes that need to be checked in order to ensure that you're doing that right, okay? All right, I'll answer a couple more questions here and then we'll move on to the Landlord Compensation Fund. If I want to move back into the home I own currently on a 1-year lease, do I need the 90-day notice? Can I serve that in April? The lease is up on July 15th. Again, this is sort of one of those qualifying landlord exemptions that you may be able to utilize. You probably would need to do it if you're looking at the qualifying landlord exemption, but depending upon when the lease is and what kind of the status of the tenancy is, whether it's the first year of occupancy or not, you may just be able to, to have some non-renewal rights down the road, which may be quicker. So again, I need to take a look at your documents in order to help you with that one. But again, you would probably have some rights and remedies there. If not, if the qualifying landlord exemption is quicker, then you can certainly utilize that. That may come with its own relocation requirements. So an evaluation of kind of where you're at and whether or not a non-renewal down the road might be a better option for you, again, down the road. Okay.
Hey, and I was jumping on that too, Chris. I just want to mention this gets to that issue that Bradley and I were talking about just earlier about whether you can do those qualifying landlord reason notices in the first year, because you're still in the first year, according to your question. And so to be cautious, we advise against issuing those in the first year because the statute references them with respect to after the first year. But again, Bradley was going to share some additional thoughts after this webinar on that issue as well, and we'll certainly pass those along.
All righty. What if you need to move a family member into your house if the tenant's first day of month to month was June 1, 2021? Again, that sort of touches on the question that Jeremy and I were talking about. I'll put together an answer on that and get you a response to that one, because that will assist on that answer. Jeremy's statement did kind of prompt that language, that statutory language in my head with regard to that, and he is on point there with regard to the after the first year of occupancy language, which is the troubling part of that statute. But again, let me put together a written answer for you, because some of these things are just better served with written responses. And the second question there is sort of the same. Will you be doing another class on no cause issues? I'm certainly able to, and I'll talk with Jeremy about that.
And we're going to keep these landlord tenant sessions going because we know how important they are to you. So definitely expect some more of these coming up in the future.
All right. So let's move on to the landlord compensation program. And a lot of this landlord compensation discussion is going to be kind of surface level discussion, because much of the landlord compensation fund is really all about their website, which is an absolute train wreck right now. As I'm sure a lot of you that have tried to work with it have experienced. So moving on, section 2 of 4401 starts with some promising language with regard to compensating residential landlords for 80% of the past due rent for the qualifying tenants, which is great. Unfortunately, there's the application requirements. So the requirements for the landlord eligibility, there's an application process. The landlords must submit an application to the Housing and Community Services Department. They must submit an application for all tenants with unpaid rent who have provided a signed declaration form. They must provide copies of all tenant declarations of financial hardship. They must provide a description of the unpaid rent for all current tenants, and they must agree to forgive the remaining 20% of the unpaid rent due from qualifying tenants that has accrued between April 1st and the date of the application upon receiving a distribution from the department. They must repay the department for any rent later received from the tenant or any other agency, or for any rent that the landlord has already forgiven. And the landlord cannot be the tenant's immediate family member. And the landlord must also agree that during the pendency of the distribution application, the The landlord cannot give a notice of termination without cause or a notice of termination for non-payment, and the landlord must provide any other information or materials required by the department. So the italicized items in the lecture handout, which I was just talking there, it's that the landlord must agree during the pendency of the distribution application that the landlord cannot give a notice of termination without cause or a notice of termination for non-payment. Okay, so that's the kicker there, because what exactly does during the pendency of the distribution application mean? I don't know. It's not defined. It's not defined anywhere in the law. I haven't seen any definition of it. So if you're working your way through this process, this landlord compensation fund, your application's pending, maybe you haven't received your money, or maybe you're receiving your money in spurts, that can have a negative effect on what your abilities to serve any sort of no-cause notices are. So let's say the state doesn't get around to getting to your application or distributing money to you through September of this year, right? And that's certainly seems like it might happen considering the problems that they're having. That may cause some problems with regard to any of your thoughts of maybe selling the property, utilizing the qualifying landlord exemption, non-renewing or serving a no-cause notice down the road. All of those sorts of things can be affected. So if you are thinking about doing that down the road, if you're thinking about serving a qualifying landlord exemption notice or some sort of a no-cause notice or a non-payment of rent notice even, and you're saying, hey, this landlord compensation fund looks like it could be something I want to explore, talk to an attorney, because again, it's unclear what they mean by that during the pendency of the distribution application. So again, that can have a significant effect on your rights. Okay. All right, the application process. So the application period is going to be open more than once, as you've seen. They've gone live right now. This handout right now was basically this portion of the handout was drafted before they implemented the system that they currently have, the website. If you Google Oregon Landlord Compensation Fund, it will take you there to an application process, and you can fill it out from there. In terms of what you need to provide, there's a variety of documents that you need to provide to them. One of those being rent rolls, again, the declaration forms, any other materials that they ask you for, you have to provide them. Okay, so it's a very document intensive process, and they're checking your stuff because again they fear that landlords are going to commit fraud in the process. So that's unfortunate because again, it seems like they only think landlords are engaging in fraud throughout this whole process. But Jeremy, do you have
Brad, I'm sorry, Brad. I just wanted to mention it's we're approaching 10:30, but we want to keep rolling if that's okay with you, because this is great information and I know people are interested. So we're gonna just keep going if that's okay.
Yeah, we're almost to the end of the handout here, and then I'm happy to answer any more questions. But if it goes on too long, I may need to take a bathroom break. So, all right. So the current funding, just talk a little bit about that. I know there's some questions here that I'll get to in a second. 150 million in the program. 50 million has already been sort of allocated, and the application period for that I think ends. I think they extended it to tomorrow. And after that, then they will, I believe, begin to distribute some things and distribute some monies. But we'll see. Again, the process right now that they have it's struggling, to say the least. And they're struggling to get their systems down and to get money in the pockets of landlords, which again causes more issues than we can discuss here. But one of the most concerning aspects of the Landlord Compensation Fund is that the department may establish any qualifications, priorities, restrictions, or limits on the distributions under the Landlord Compensation Fund. And as I'm sure you've seen, if you've looked at the landlord compensation fund, there is a weighted system that they utilize in order to determine who is more eligible than somebody else. So it goes to a couple of different factors, one of which is portfolio size, so how many units you have, which negatively affects larger landlords. And I mean, that obviously helps small mom and pops, which is good. They need that help. But obviously, non-payment of rent situations or tenants not paying their rent doesn't discriminate as to portfolio size. The other weighted factor that they utilize is how much unpaid rent in terms of percentages that you have. And if it's, I believe it's 0 to 50%, or it's, I think 100% to 50% unpaid rent, I think gets the 50 points. I'd have to take a look at the weighted system, but again, it's weighted based upon how much unpaid rent your tenants have. Does that mean that some landlords will be left out in the cold and denied compensation based upon the landlord compensation fund? Probably, yes. The amount of money that they have allocated to this problem is nowhere near sufficient to cover the scope of the problem. That doesn't mean that you won't have rights and remedies down the road, but in terms of getting money from the state, some landlords may be left without that right, that remedy through the landlord compensation fund. But again, keep in mind that the biggest drawback to the landlord compensation fund is the requirement that the landlord waive 20% of the unpaid rent. And that all but wipes out what I would venture a guess is your profit margin. And that's unfortunate, but it seems as if our legislature believes either that A, landlords caused this problem, or B, landlords are just raking in the money, neither of which is true. Finally, and after this point, I will answer some questions. Could the law change again? Yes, it could change again. It changes rapidly. It has changed many times since March 2020. If it changes again, I'd be happy to address it and provide you some insights going forward. But again, state, local, federal law all cause, and they all factor into the analysis. Okay, so I cannot stress this enough, and I know that it's a problem to work with an attorney because it does cost money. But if you are thinking about taking steps forward directed at your tenant, directed at your tenancies, please work with an attorney. It is far easier to address problems on the front end than it is on the back end. It's easier for my life. It's easier for your life, which is important because when it's easier for your life, it is easier on your checkbook. All right, so that is the lecture handout. Let me address a couple of questions here. Is a bank able to use landlord exemption in an REO sale? I'm not quite sure I understand the question. It's probably something that we need to discuss more in terms of what your actual situation is. So I'll pass on that question. Feel free to shoot me an email. I'd be happy to discuss that with you further. So to confirm, 30-day notices need to be given between July 1st and July 31st for a first year no cause termination. So it's actually July 1 and April 31st. But again, if you're looking at utilizing a no cause notice for a tenancy that is in the first year of occupancy, that is an option to you because again, the first year of occupancy was expanded. It was extended. So yeah, something that you definitely can look into. Sounds like your facts support it. But again, definitely work with an attorney on that, I would say. All right. Tenant is in the second year of their lease. The lease ends on June 30th of 2021. Owner wants to move an immediate family member into their property, their son. The lease ends June 30th, 2021. Okay to do a 90-day notice to get the immediate family member into the home. The property is in Portland. Yes, you can certainly do the 90-day notice, be a qualifying landlord exemption. The only problem with that is you probably would have to pay some relocation assistance. And so working with an attorney on that is going to be important because the main issue with regard to relocation assistance under the City of Portland rules is that state relocation assistance is required to be served along with the notice itself. The Portland relocation requirement allows it to be basically 45 days after service of the notice or prior to the termination of the notice. But if you pay the Portland requirement along with the notice itself, then effectively you're able to not pay the state requirement. And the math on that kind of works out in a unique way. But again, that's where it's important to work with an attorney, because they can save you some money. Because if you don't pay the relocation assistance with the notice itself, then effectively, if you're required to pay the state relocation assistance, you have to pay that with the notice. And then if you pay the Portland relocation assistance after that, as would be your right, you would have to pay that on top of the state relocation assistance. But if you pay the Portland relocation assistance along with service of the notice, you effectively only have to pay the Portland relocation assistance under the Portland rules, okay? And I know that sounds complicated, and I'm not good at math either, but that's the way the math works out, okay? So that's why it's important to talk to an attorney. Where can we find more information on rights for landlords who want to sell their properties when tenants do not owe any money? The tenant or the owner just needs to sell. So the statute is ORS 90.427. The qualifying landlord exemption is under 5D. And if you need any more information, I'm happy to help you. With whatever you need there, but that's effectively what I can tell you in terms of information. If you're looking for some sort of a handout that is going to be on the internet, one, I don't think one will exist. Two, I don't know if I trust it. So, and finally,
I will say just we have on our website, we have summaries and FAQs related to both 4401 and also Senate Bill 608, which is what created these landlord-based reasons, Justin. And so if you go to the Oregon Realtors website, you can find some more information there. But Bradley is correct. It essentially is just repeating what you'd find in ORS 90.427 subsection 5. But we do have those on the Oregon Realtors website.
All right. So just checking, I have a client who has a tenant with a lease expiring July 1. Does she have to notify her tenants that she will not be renewing the lease 90 days before? So again, it really depends. So the question that you're asking there, I think, depends on where you're at in terms of the first year of occupancy. If you're in the first year of occupancy, then no, you can, the non-renewal, the first year of occupancy would extend to August 31st. So you may be able to do a straight, a straight no cause after July 1. If you're after the first year of occupancy, so you're in the second year of occupancy or beyond, the only thing that you would be able to terminate the tenancy for is cause or a qualifying landlord exemption. So again, that's kind of where the devil's in the details there. I think you're muted, Jeremy.
One final question, which was a follow-on to the REO question in the Q&A. Can a bank owner use the qualifying landlord exemption and give 90-day notice to tenants so that the property can be vacant?
Yeah, and it's something that I don't know the answer to off the top of my head, simply because I think there's more facts here that I'm going to need in order to advise on that. So if this individual could reach out to me directly, I'd be happy to address that question with them. But in terms of kind of the qualifying landlord exemption, any landlord can utilize them. So whether or not that bank technically would be the landlord, I don't know the answer to that. Probably not. But they could also, and again, this is the problem, is I don't know what the situation is with the tenants. I mean, if they are the individuals that own the home, and they are becoming tenants afterwards, there are some rights and remedies after, with a with regard to foreclosures with somebody not occupying. So again, I'd encourage this individual to reach out to me directly, and we can talk more about their particular situation, because there's just too many facts that I don't think I have that I would want to know about before I'd answer a question like that.
Great. Yeah. Thanks. Spoken like a good attorney.
Well, the malpractice is certainly a problem when it comes to these moratoria and the like. So I'm happy to give the answers that I can spout off the top of my head, but sometimes there are just some facts that you need before you feel comfortable answering.
Absolutely. And hey, there's one more thing, and I'll just cover here. Is this that the question was about the is it July 1st, 2021, or after July 1st? So all these rules that we're talking about, they go to June 30th, and then July 1st, 2021 is the first day that you can issue the no cause notices.
Yeah. So the main takeaway there is hopefully life goes back to normal on July 1st. That's kind of what we're all hoping for. Again, there is some pending legislation that will potentially extend the grace period through February of 2022. What that grace period encompasses, we won't know until it passes, if it passes. But again, the main takeaway is that I have not seen or heard anything to suggest that the eviction moratorium will be extended past June 30th. So here's hoping on that.
Well, Bradley, I don't know if you saw it in the chat, but all of the comments coming in about thanking you and telling you how informative and well done this presentation was. But I would absolutely agree. And we just can't thank you enough for breaking this down in a way that folks can understand and that really helps them, particularly with some of these trickier questions that you've been very good and quick to answer in the chat and in the Q&A. So it's just, we can't thank you enough. We would love to have you back again for a future webinar to dive deeper on these issues if the legislature continues to pass legislation, or perhaps diving in more specifically on no cause and landlord termination issues. But we just so appreciate you for doing this.
Thank you all so much. I appreciate everybody being here. You're all far too kind. Sometimes I understand that a lot of this is me talking, and a lot of it, especially when I'm doing it myself, I think to myself, man, that sounds complicated. It is complicated. All of it's complicated. If any of you need any assistance, I put my email in the Zoom webinar chat, and if Jeremy can distribute that as well, if anybody that asks, that'd be great. I'm always here for you. I'm not going anywhere like I'm still hopefully somewhat young, but a lot of these laws are starting to drive me a little bit insane. So I can see why people are having some struggles with it. But if you have any questions and need any assistance, feel free to reach out. I'm happy to assist.
Excellent. Well, thanks again, Bradley, and everyone. You should have received the handout in an email. If you did not, please let us know, and we'll make sure that you have Bradley's email address as well. And we will be keeping you all updated on updates in the legislature to landlord-tenant related laws. Hopefully, you're all checking out our weekly Advocacy in a Minute video that we put out on Fridays, as well as our monthly podcast where we're describing the progress and status on different legislation. I will also mention that the federal government has sent our way quite a bit of additional rental assistance dollars from the stimulus packages they have passed. The state is still trying to figure out how to use that money and get it out. It's likely going to be through the tenants applying for it and then it coming to you rather than through this landlord compensation fund. But there are some resources that are out there trying to help with some of this back rent, but the state's been having some trouble getting those dollars out the door, but we'll keep you posted on the progress there. Yeah, so we'll be back again with future webinars and certainly with future landlord tenant webinars. Bradley, Thanks for your time this morning, everybody. Thanks for sticking with us for a few extra minutes, and we hope that you have a great week.
Take care, everyone.